Right. Hello, everybody, and welcome to this seminar, which is on the subject of deprivation of liberty. Well, I'm delighted to be joined by Chris Callender, who is the head of Civil Litigation at Just for Kids Law. And Chris and I have put this seminar together, which is designed to try and navigate you through uh, the maze, the labyrinth, which is deprivation of liberty. So we will have questions at the end. We will be sending you individually slides. There are also some detailed notes as well, and I think there's an audio recording. So anyway, without further ado, Chris and I will continue with the seminar. So first of all, let's look at deprivation of liberty. Now, the title that was advertised is Deprivation of Liberty Safeguards, and that is a misleading title, and I claim full responsibility for that. But what you've got to realize is that deprivation of liberty is a concept. You cannot deprive someone of their liberty without legal authority. So you need to start off from that legal assumption. It's absolutely key to understand that. If somebody is deprived of their liberty, there has to be a lawful authorization. It's not enough for an institution to say, oh, well, we were worried about so-and-so sort of crossing the road or whatever it might be. They have to have a lawful authority. If they don't have that lawful authority, then essentially that person will either have a claim for damages, they'll have a claim in human rights, whatever it might be. It will be unlawful, basically. That's why we have all these cases. So the right not to have your liberty deprived is enshrined in something called the European Convention on Human Rights. And Article 5 is the actual article that protects our liberty, and it says that everyone has a right to liberty and security of person, and no one shall be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. We've also got Article 8, which protects our right to respect for private and family life. So the Human Rights Act says that when a court looks at a deprivation of liberty, it has to apply the issue of human rights. So human rights is like an overarching thing. Whenever you're looking at whether it's Mental Capacity Act, Mental Health Act, the Human Rights Act will apply and the European Convention will apply. That's why it's so important. So there has to be legal authorization. So could we have the next slide, please? So looking at this term deprivation of liberty safeguards, it has caused some confusion. Deprivation of liberty safeguards is a term that comes from something called the Mental Capacity Act, basically. And that act only applies in relation to children who are 16 and 17 years old. And there is guidance produced, and that guidance mentions something called deprivation of liberty safeguard or DoLS, but it's not correct to use it in this sort of overarching general being deprived of liberty. The thing to do is to say, has this client, has this young person, child been deprived of their liberty? So safeguards refer to a particular legal authorization that can be made, which we'll be looking at in a moment. But just that's very important to understand. Okay, so there's a number of ways in which children and adults can be lawfully deprived of their liberty, but we'll be looking at the mainly children and adults. Obviously, there are other types of people. So what are the main legal ways? Well, the main legal ways are under the Mental Health Act 1983, under the Mental Capacity Act 2005, which only applies to children who are 16 or 17, and that will apply mainly to hospitals and residential homes, but it can also apply in other situations. So that's the Mental Capacity Act. Mental Health Act is about children who are put in mental health hospitals because they've got a mental disorder. And then we've got something called the inherent jurisdiction of the Family Division of the High Court. Now that's when the Mental Health Act and the Mental Capacity Act isn't going to work, or it's not appropriate. And this is a sort of like a catch-all way of restricting someone's liberty, and as we'll see later, it's being increasingly used because the other methods aren't working. You can also deprive someone of their liberty under something called the criminal law as well. So if a child is sentenced or put on remand, their liberty is deprived. But again, there's lawful authority behind that. And finally, we've got Section 25 of the Children Act 1989. And that means secure accommodation or secure children's home, which had their own regime. Okay, could we have the next slide? So, what is deprivation of liberty? Deprivation of liberty doesn't mean just being put behind a locked door and locked up. It can be quite a subtle thing, and this is why courts have had to deal with it. But you can be deprived of your liberty if you're no longer free to do what you want. You're under continuous supervision. You're denied access to your possessions, mobile phone, jewelry, etc. You're not permitted to come and go. And when you're transported from one place to another by means of secure transport as well. So you need to be alert to any situation where a child appears to be forced to do something or is somehow confined. And you need to reflect on whether that confinement goes beyond the type of restrictions ordinarily imposed upon a child of the same age. So deprivation of liberty can include a locked room, building, continuous monitoring, supervision, high staff to child ratio, use of CCTV, restrictions on movement through the use of physical or chemical restraint. Again, without lawful authority, it's illegal. Okay.
So thanks, Malcolm. I'm going to deal with what's often referred to as the stalk test, which is a legal test for the deprivation of liberty. The stalk test is called the stalk test because it's named after a particular legal case which was brought to the European Court of Human Rights. And there are essentially three tests or limbs to the stalk test. The first limb, so the first question you might be asking is, was the length of time that someone was deprived of their liberty more than negligible? So simply holding someone's arm for a number of seconds, or whatever that deprivation might be for a short period of time is unlikely, therefore, to be a deprivation. But every case is situated or determined on its facts, and also the court will have in mind whether or not it's an ordinary situation for a child to be deprived by their family. So they will be thinking objectively. They'll be thinking, is this the kind of situation that might arise in a normal family setting? And if not, then quite possibly we're in the realms of a deprivation of liberty. There's some case law on this. Sir James Mumby, who was the president of the family division, described or tried to assist us with the quote here from his judgment. So again, looking objectively and looking at the facts, it's all very fact sensitive. So a child at the age of 10 under constant supervision is unlikely to be confined, but an older child, possibly even 11, depending on their own abilities, may well be a child who's deprived. And again, it's just very fact sensitive. And there's the case of P in Cheshire, which we'll go into more detail later on, or Malcolm will, which added further definition to what do we mean by deprivation. So first test is, was the confinement more than negligible? The second test is whether or not consent. Now, in respect to children, consent or competence is a much more complex area of law. And so a child who is 16 or 17 is assessed on the basis of whether they have capacity. So they're treated in a similar way to adults. Do they have capacity to consent to their confinement? Whereas if they're under the age of 16, then we refer to the case of Gillick, and therefore whether or not the child is competent to be able to consent to that confinement. And understanding whether the child is consenting and therefore has capacity or is competent consent is absolutely intrinsic to the second test as to whether or not they have consented to the confinement. The third test as to deprivation is whether the state has any responsibility. So we sometimes referred in legal terms an assumption of responsibility for that confinement. Human rights law only applies where there is a public body involved. So privately run clinic, for example, wouldn't be impacted by the European Convention unless the state has some role in arranging for the child or young person or adult for that matter being placed in that situation. So in the example of, say, a private children's home, being placed, if a child who is looked after by a local authority is placed there, the state has assumed responsibility because the state has arranged for the provision of that accommodation, and therefore the European Convention would then apply. Just giving some more examples of where Article 5 would be engaged. Then there's the question of consent and competency. So a child under 16, they are, what we're looking for is competency. There's the case there of Gillick, which is an interesting read. So I would recommend it if you get a moment, where it talks about the ability of a child to competently give consent. In that case, it was a child under 16 who had consented to medical treatment, contrary to the parents' wishes, and the question about whether or not that was lawful. In the case of Lincolnshire County Council and TGA, question there was whether a parent could consent to confinement of a child where there was no issue or dispute that the confinement was in the child's best interests. And the court there found that it wasn't possible for the parents to consent to this confinement without court approval. And then there's the case of D around what happens when a child reaches the age of 16, and again, the role of parental responsibility and parental consent, and whether that could be lawfully applied or provided. Important legal case around local authorities consenting, and this is the case of J. And in that situation, everyone thought it was in the best interest of the 14-year-old boy J to be deprived of his liberty. He was unable to express his wishes or feelings. The court concluded at the High Court stage that it was appropriate for a local authority who had parental responsibility to be able to consent to the deprivation. That was appealed by almost everybody involved in the case, and the Court of Appeal found that it wasn't possible for a local authority to consent, and it would be necessary for the court to be approached and an application to be made. Important point here, because it's in regards to the rights of children, and to ensure that there is judicial scrutiny where deprivation of a liberty arises. Malcolm, I think we're over to you.
Yes, thanks very much, Chris. So we're now going to look at the Mental Health Act 1983. So this is one of the first ways in which you can deprive somebody of their liberty. I mean, obviously it's not used very much, but it's used where a child has a mental disorder and they need to be confined to a hospital where they can receive some kind of treatment. So what the Mental Health Act does is it provides this legal way of confining people, but at the same time it provides a legal regime which allows you to challenge it from the inside. So very briefly, it allows the state to detain a person for up to 28 days under Section 2, up to 6 months under Section 3, 72 hours under Section 4, and in the case of a person of 16 or over, Section 7, there's an application for guardianship. Now, you can detain a person, but it can be initiated not just by the hospital, but also by a nearest relative as well. And the police also have powers under the Mental Health Act, so they can go into someone's home and they can detain them in a public place and they can take them to a place of safety. So there's a number of ways in which it can be initiated: police, nearest relatives, hospital, basically, but it means that a person can be confined. Could I have the next slide, please? Now, the Mental Health Act 1983 has a code of practice. Now, a lot of these acts that we look at all have a code of practice, and they're really written for people like you. So rather than having to plow through the act, it's always a good idea to have a look at the code of practice, which is available on the internet, and in the notes we've given you the link. So this code of practice is issued alongside the Mental Health Act, and it's basically a manual, and it's written in plain English. Chapter 19 is a bit that deals specifically with children and young people. So these are people under the age of 18. So let's call them children. Now, Chapter 19 makes a point that if you are a child, you're not just covered by the Mental Health Act, you're also covered by the Children Act 1989 and 2004, which means that you are a child in need, you may be a child in care. The local authority will need to be involved, basically. So the best interests of a child must always be a significant consideration. Paragraph 19.6 say that those with parental responsibility have a central role in relations to decisions of admission and treatment of their child. And paragraph 19.11 draws a distinction between children subject to a care order and children coming under Section 20, where the parents will still be the nearest relatives, basically. But a local authority can still limit the extent to which parents may exercise their parental responsibility. So if you have a child who's in a mental institution, that's the chapter you should be looking at. Now, what does the code say about consent? So as we've just heard from Chris, certain children can or cannot consent. If you apply this Gillick test to them, do they have sufficient intelligence? Can they actually, they do have the capacity to consent? So the first point to make is that the law is different for following groups of people. So if you're a child under the age of 16, you come under a different regime. If you're children who are 16 or over, then that's a young person. Now, if it's under 16, the question as to whether you can consent is whether you're Gillick competent. So you could be 14 years old and you could be assessed as able to consent because you've got sufficient intelligence. The next question will be, well, are you actually consenting? Have you actually said that you do? Can't be assumed. If you're 16 or 17 and the position is different, it's a different test. And the test is set out in a different act called the Mental Capacity Act 2005. And paragraph 19.38 of the code says that in relation to 16 and 17-year-olds, if decisions are to be made in accordance with the Mental Capacity Act within the meaning of the MCA, those with parental responsibility should be consulted about the best interests of the young person. And paragraph 19.39 says parental consent should not be relied upon when the child is competent or the young person has capacity to make a particular decision. So two different regimes when we're looking at consent for under 16-year-olds, basically, and children who are 16 or over, 16 and 17-year-olds. A quick word about independent mental health advocates, because if you're given a case, then if you're not an IMHA, there's a good chance that whoever you're acting for is entitled for an IMHA. And these are specialist advocates, and the Mental Health Act obliges a local authority to provide help to qualifying patients, that's going to include children, by offering them IMHAs. And it tells you there what a qualifying patient is: adult, child likely to be detained in a psychiatric hospital. And there are regulations that set out how IMHAs are meant to work, basically. IMHA must satisfy certain requirements, etc., basically. And you can see the guidance as to how they act in the Code of Practice issued under the Mental Health Act 1983. Now, There's also a complaints process, which you can use under the Mental Health Act 1983. So if you're the person on the spot, there's no one else there, but you want to make a complaint, the Mental Health Act 1983 provides a process. Again, you'll find the code helpful. Next slide, please.
To me, on the Mental Capacity
Yeah.
Act 2005, so this provides the statutory frameworks. This is the law, the Act of Parliament, to help us understand how we make decisions for people who lack capacity to make decisions for themselves. And just as a reminder, this will only apply to children who are aged 16 or 17 and also found, importantly, to lack capacity. So this does not apply to children under that age. So there's two main routes, the way that authorization can be obtained for the deprivation of liberty. And a reminder, if you haven't got authorization, then it is unlawful and illegal, and potentially the child or young person may have a claim for compensation. So firstly, where the individual, the person, adult or child is placed in a hospital or care home, and the staff there believe that they need to take steps to restrict that person's liberty, their freedom, then they should apply to what's called a supervisory body. Typically, a supervisory body is the relevant local authority. The relevant local authority, once it's received that referral, then needs to take steps to have assessments, of which there will be 6, which will be undertaken by 2 separate assessors. One is described as the best interest assessor. So what is the best interests of the person concerned? And then a mental health assessor who is looking to establish, to assess, to verify the mental health of the individual whose liberty is to be deprived. This is a process that must absolutely be gone through, failing which there is no authorization or lawful authorization, and there are qualifying requirements as a result of those assessments. So if the assessments say, yeah, this is necessary to protect the person, it's in their best interest, then what's called a standard authorization would be granted by the local authority. But imagining the scenario where the individual is in the community, or what we're talking about here is a person who is 16 or 17, in which case this authorization process through the supervisory body does not work. That is not the way to lawfully deprive someone. An application would need to be made in the Court of Protection, and that application would typically, expectation is, be made by a local authority. I can say in my practice, I've had situations where local authorities have been slow to act, or even challenge the assertion that the child lacks capacity, in which case, in very exceptional circumstances, an application could be made in another way. And I rather tenaciously made the application myself in the circumstances of a 17-year-old being released from prison who plainly lacked capacity, and that application was eventually succeeded. So those are the two routes that one would go. So what does lack of capacity mean? Section 2.1 of the Mental Capacity Act. So you need to go to the Act itself. So a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind and the brain. Eventually, a court would only be satisfied if that criteria is met, where you have a medical professional or one of the assessors referred who would come to that conclusion. It cannot simply be a case of the person's age or how they appear or how they behave alone. That's not sufficient. So then there would be an application. There are standard forms we use to the Court of Protection for a deprivation of liberty, and that can be made by a person with parental responsibility. So it could be made by the local authority or the parent or a special guardian or the local authority itself, and that would be the normal route. Um, and even where a child or young person is not a child who's looked after by the local authority, one would still expect the local authority to make that application. And of course, in order to make that application, there has to be some evidence that the 16 or 17-year-old actually lacks capacity. Prior to making that application, certain steps should or in fact must be made. I guess there would be exceptions subject to urgency, but in any event, the applicant must consult the child and tell them that there is an application being made to court, that the application concerns whether or not they lack capacity, and if so, the court could authorise or should authorise a deprivation of liberty. Also, what arrangements the local authority are applying, if it is the local authority, around that. Is it about access to social media? Is it about transport arrangements? Is it about they can't go out after 8 o'clock? What are those arrangements being put in place? Absolutely essential that the child has the right to express and that those wishes and feelings and views are recorded and then communicated to the court. They have the right to take part in those proceedings, to be there, to be part of it, to attend if appropriate. Typically, judges will be very keen and interested to hear the thoughts and wishes of the child in those proceedings. And also that there is help so they can have their own lawyers represent them, for which there is legal aid still in order to challenge or to vary the proposed arrangements, and that the local authority needs to identify who can act as the child's representative. So the local authority issuing those proceedings should be considering which lawyers or which lawyers could the child or young person go to. Children under 16, obviously advocates should be alert to the possibility that the child may be unlawfully deprived. And in another role, often was receiving queries from advocates describing situations such as the local authority arranged for secure transport to move child from one home to the next. Is that a deprivation? And what one is inclined to think the idea or the need for secure suggests there is some form of a deprivation which requires consideration and potentially clarification as to whether the child consents or whether parental consent is required, etc. So there is the codes of practice. Always worth going to the codes of practice, whether lawyers or not, because the codes of practice often describe in quite a straightforward way what the law is, what the rules are, what's the procedure, and expands on the parliamentary language that's often used in acts of parliament. Two codes that the government published. One is the Mental Capacity Act 2005 Code of Practice, and look at chapter 12 because that deals specifically with children and young people. And the other code of practice is entitled Deprivation of Liberty Safeguards Code of Practice, which supplements the Main Capacity Act 2005. Very snappy little title. Again, chapter 10 is where to go when looking at the court of protection procedures. And again, we, as Malcolm's already talked about, and explained around the role of IMCAs or independent mental capacity advocates, and absolutely essential where possible that arrangements put in place with the young person to have access to that advocate to assist them in ensuring that their wishes, feelings and views are communicated through sometimes what's quite an intimidating legal procedure. And section 35(1) requires local authorities to make sure that the arrangements are in place for an advocate if so required. And now over to Malcolm.
Thank you, Chris, for explaining how the Mental Capacity Act works. So that is number 2 legal way of depriving someone of their liberty. So we've done the Mental Health Act, we've done the Mental Capacity Act. Now what we're going to do is we're going to look at a case called P versus Cheshire. Now this is a very famous case and it's very well known, and it's about disabled people and whether you can deprive disabled people of their liberty. So we've got the UK Supreme Court, that's the highest court that we have in the UK, and the court looked at the definition of the word deprivation of liberty. So the facts are that we have an adult born with cerebral palsy, Down syndrome. He needs 24-hour care, and local authority obtains orders from the Court of Protection that it's in B's best interest to live in accommodation arranged by the local authority. So he lives in a staff bungalow with other residents near his home, and he has one-to-one support to enable him to leave the house, basically. And then we've got another 2 cases. This is P and Q. Now they're sisters, they're under care proceedings. They both have got learning disabilities. So all these people are adults, but they're disabled. And one was placed with a foster mother and went to an education unit daily. She never attempted to leave the foster home by herself, but would have been restrained from doing so had she tried. And the other was moved from foster care to a residential home for learning disabled adolescents with complex needs. She sometimes required physical restraint and received tranquilizing medication. So these people aren't being locked up, but their activities are being restrained. So the question for the UK Supreme Court is, are we looking at a deprivation of liberty? Could I have the next slide, please, Chris? So the UK Supreme Court had to look at this and say, are we looking at deprivation of liberty? So what the court said was, the court said, it may be that these people are being looked after and it's all in their best interests, or it may appear to be in their best interest, but a gilded cage is still a cage. So the UK Supreme Court set out what they called an acid test, and it's whether a person was under the complete supervision and control of those caring for them and was not free to leave the place where they lived. Now, of course, the care homes say, well, the reason why we restrain these people was if they went across the road, they'd be run over. So we're trying to save their lives, but that's not actually the test at all. So the UK Supreme Court said the question as to whether a person was restricted was determined by comparing the extent of their actual freedom with somebody of their age and station whose freedom was not limited. So if you took these people with learning difficulties and you said, well, what would you do if it was an adult, basically, of the same age? And you tried to do that to an adult, would their liberty be deprived? That was the acid test. So thus a teenager of the same age and familiar background as P and Q was a relevant comparator for them. So even though the supervision and control was there to protect them, there still had to be proper safeguards. So both P and Q were deprived of their liberty, and as neither had capacity, so they couldn't consent, they required a periodic independent check. Now, the UK Supreme Court said that P, he was the first one, and he had cerebral palsy. He'd also been unlawfully deprived of his liberty. So that effectively widened the definition of the term deprivation of liberty under the Mental Capacity Act because it came under that act, but it refers to other deprivation of liberty under the Mental Health Act, criminal law, whatever it might be. Now, the effect of P versus Cheshire West was to widen the definition of deprivation of liberty. So it caused, for want of a better word, it caused problems because, of course, care homes are doing this all the time. And it led to a rise in applications being made for deprivation of liberty authorization, and that created huge backlogs, basically. So the government has estimated that there's something like 400,000 incapacitated people who are being deprived of liberty on an annual basis. That gives you some idea of how big the problem is. Now, we now have a legal case from Northern Ireland. Now, it's called reference by the Attorney General for Northern Ireland. Now, what that is that the Attorney General for Northern Ireland has gone to the government and they put a question, and that question then goes to the court. And in this case, it's the UK Supreme Court. So they say, look, we've got this legal problem as to deprivation of liberty. We want to put it to the UK Supreme Court. But effectively what it is a challenge to P versus Cheshire West. So you've got the question there, which is right at the bottom, which is, does the Minister of Health for Northern Ireland have a power to revise the Deprivation of Liberty Safeguards Code of Practice? So we're talking about the Mental Capacity Act, the equivalent in Northern Ireland. What they want to do is they want to revise that code so they get a tighter deprivation of liberty definition. That's the general idea. And the question is, well, can we do that legally in Northern Ireland? Because if they can do it in Northern Ireland, they can do it in England, Wales, Scotland as well. So it's a very important case. Now, what's happened is that, thanks, Chris, what's happened is that the UK Supreme Court hasn't actually made a decision as yet, but we will have that decision because the arguments have all been made. We will have that decision perhaps in a month or so. Now, these are what the parties are saying. So various parties have come along who are interested in this issue, and they made submissions to the UK Supreme Court. So the Attorney General basically is saying the test should be that if they've got capacity to understand, retain, appreciate, use and weigh the fact of being confined, and even if they do not have mental capacity, they actively express positive wishes and feelings about the arrangements. Now that's where it's being widened out. So even if you've got a learning difficulty, if you can express positive wishes, then the deprivation of your liberty will be lawful. MenCap Mind and the National Autistic Society, they take a different view, obviously, as one would expect, and they oppose this attempt to revise the code of practice on the grounds that it's an attack on the rights of disabled people. And then there's a Department for Health and Social Care. They're also involved, and they've made representations, and they take the view that P versus Cheshire is wrong. It's taken a wrong turn. It's too wide. We need to restrict it. So the DHSE have come up with a very different multifactorial test. Now, it's possible that if this case goes the way the government wants it to go, the way that the Attorney General for Northern Ireland wants it to go, then we will end up with a test that looks something like this. So is the individual free to leave the place? If they succeeded, did they have to be forcibly returned, whether they've been physically restrained? Are they chemical restraints, degree of supervision, social isolation? There's a whole series of factors there. So we might have something like that, but it's too early to say. And whatever the court says, it will then go into deprivation of liberty safeguards guidance. So the guidance that we looked at under the mental health capacity will need to be revised. You will see something new, but it will also affect other people, as I've said, because if the definition of deprivation of liberty goes wider, then that affects people under the Mental Health Act. It also affects people under the inherent jurisdiction of the High Court, which we'll look at in a moment. So this is a very important case, but as yet, we don't have a decision. So a new regime for the Mental Capacity Act 2005, basically. There has been a move by the government in recent years, to try to amend the Deprivation of Liberty Safeguards. So this applies to the Mental Health Act 2005. Now, the government made an act, it's called the Mental Capacity Amendment Act 2009, and introduced liberty protection safeguards. And that was intended to replace the 2000 Act regime. Now, you don't need to worry about this, but for some odd reason, this has never been implemented. It's quite common now for governments to make acts of parliament which never get implemented or never are implemented for years. And I think it will await this Attorney General's case, basically. So it looks like that we may have a new regime. It depends what the UK Supreme Court says.
And there's a link there, just if you want to see in more detail about where things have got to on that. So I'm going to talk now a bit about the inherent jurisdiction The Family Division of the High Court, another snappy title for a legal procedure. Essentially, the inherent jurisdiction of the High Court is basically says um, when no other law appears to work or apply, or other procedure, then the High Court can step in and make decisions on behalf of individuals before them. So we've talked already about the court protection for 16 or 17-year-olds as a ways or means of being able to restrict a child's liberty. The inherent jurisdiction of the family division is a wider ranging way in which children's liberties can be restricted, and it's become increasingly used. Statistics from government social research in September 2025 says that 2,500 children in the years 23 to 24 had restrictions through this method applied to them, and there are reasons for that, which we go on to talk about. So the inherent jurisdiction, the practice direction. I don't encourage people to go read practice directions and the civil procedure rules or the family procedure rules, but if you want to, it's there. It's public. So it's the duty of the court under its inherent jurisdiction to ensure that a child is subject to proceedings is protected and properly taken care of. And so it's when things start to unravel, things start not to work, the court can then push in and make orders and intervene to protect the child. However, the restriction on a child's liberty through this route, the inherent jurisdiction, is tightly controlled and should only be used as a last resort. But with the way that things have evolved, austerity and lack of services, the last resort is becoming a more regular situation. So it's when there is no other statutory order available, and we'll look at those that are, and it's only there where the court or those applying have reasonable cause to believe the child is likely to suffer significant harm without the court intervening. It can include children up to 16 or 17. Now, we've talked about that as a group of children who may have restrictions as a result of an application to the court protection, but that would require the 16 or 17-year-old not having capacity to consent. So you could have a 16 or 17-year-old who is capacitous, but for whom some kind of deprivation is required for their own safety and their own best interests. In the case of inherent jurisdiction or an application, whether or not the child is Gillick competent isn't relevant either. Now, one footnote to all of this is that inherent jurisdiction is not available where a child is 17 years of age, not looked after by a local authority, and the parent does not give consent. So in that situation, it would be the court couldn't intervene. So where a child is subject to inherent jurisdiction, they must be separately legally represented. There is legal aid available for this and for the child to be legally represented. A CAFCAS guardian would be appointed by the court to assist the court and would be the person who in theory should be letting the court know the wishes and the feelings of the child. There would be regular reviews by the court of the child's continuing in confinement. So there would be a number of hearings listed. And where the court will want to be assured and will need to know that their child or young person, where restricted, including 16 or 17-year-olds, would be living in accommodation where they receive care, not supported accommodation where they actually receive care, proper care, which is registered and inspected by Ofsted, or in the case of Wales, the Care Inspectorate. And in September 2023, the president of the Family Division of the High Court issued stern guidance. And I think it's right just to comment that the High Courts have become pretty fed up, I think, of numerous applications with very impossible, difficult situations where essentially there should be another route to looking after the child or securing the child's best interests. But inherent jurisdiction applications are being made because it just simply isn't appropriate placements. And there's a reference there to being having urgent registration because local authorities are using accommodation which isn't suitable or appropriate. Nuffield Family Justice Observatory in the year up to June 2023, 1,249 children deprived of their liberty. And so the statistics, so that has dramatically increased following the statistics that were, as we see there, recorded for the years 23, 24. So massive increase in these applications. To the frustration, no doubt, of High Court judges and the High Court itself, and also increasing the costs to local authorities when they're making these applications. So just to give comparisons, 963 children, young people detained under the Mental Health Act, 221 as a result of applications under Section 25 of the Children Act 1989, 156 16 and 17-year-olds under the Mental Capacity Act, as we've seen, a massively significant more amount under the inherent jurisdiction route. And so it has become the most common route, which, as I say, has caused significant frustration to the High Court and to judges sitting there. It would be remiss of us not to talk about other ways that children can be deprived, but through the criminal justice route. And so I'm just going to very briefly touch upon it. This could be another course in its own right. Maybe Malcolm will follow up with another hour in the not too distant future on this area.
Only if you'll help me, Chris.
So, two different types of ways of securing children through the criminal justice route. One is young offender institutions. There are only 4 left now in the country. There were many more when I first started in my legal career, probably certainly at least 20, if not more. So young offender institutions are governed by the Young Offender Institution Rules 2000. That covers complaints, conduct of staff, the duties of staff, the whole way the prisons are run. But then you need to go further into a library, a complex library of prison service orders and prison service instructions. Do not encourage you to look at this really chaotically and very poorly arranged series of orders which govern, really importantly, how children and young people are segregated, how restraint is used, how the complaints process is operated. So that's young offender institutions, and it's very similar to the adult system essentially. And there's one secure training centre left. There were 4 when I arrived in the legal world, now only 1 in Milton Keynes. That is governed by the Secure Training Centre Rules 1998, which requires there to be what they call a grievance procedure, what we know as complaints procedure, and that should be run locally and set up locally. And again, those rules govern the way that restraint should be implemented. And I guess around all of that, there is other guidance and policy documents which explain how prisons or secure training centres should be run and operated. Children are sent there under 2 routes. One is because they have committed a crime for which they're pending a trial or being sentenced. That's called on remand to custody. And the other children are there because they are serving a sentence, of which there are 2 types: a detention and training order, or what's known as Section 91, which is the longer sentence for the more serious offences. A child who is remanded to a YOI or a secure training centre, importantly, becomes automatically a child who is looked after by their local authority. So really important to understand that they should be allocated a social worker, and their period of time in detention while on remand should be overseen by a local authority. The use of restraint, the way that they can be restrained or restricted. Obviously, they're in prison cells. I mean, an STC or a YOI is a prison. They're locked in a room. They can be placed in segregation units. They can be punished. They can be deprived of all sorts of things on the decisions and judgments of prison officers or those who manage or restrain them. Again, lots more detail that could be expanded on, but not here and now. Again, complaints procedure, there is specific complaints procedure to prisons, which ultimately goes up to the Prison and Probation Ombudsman. If you wanted to follow that route, secure training centres have their own internal complaints procedure. Slightly mindful of the time, so forgive me for sort of trotting through this, but there are secure children's homes, 52 when I first started, now down to 14. Very expensive, very staff intensive, and they're much smaller units compared to young offender institutions or the secure training centre. It's approved by government, has to be registered. There are 14 in the UK, 13 in England, 1 in Wales. They are operated, they're managed by the Children's Homes Regulations 2015, where there is a lot of detail about how they should be run and managed. There is a new place which is now situated in Rochester, which was formerly known as Medway Secure Training Centre and is now called the Oasis Restore Secure School. It's a very small operation at the moment. I think there's only about 6 or 8 children there, extremely complex needs. And now it must be a question mark as to whether that will expand or even exist in time to come. And again, there are the relevant regulations there in terms of what happens when children's homes become secure or a secure accommodation. Now, the way that a child would end up in a secure children's home, firstly, you could be placed there if the youth custody service who places children as a result of criminal proceedings in secure. So secure children's home do have children there as a result of being charged with a criminal offence. More typically nowadays, it's because of an application by a local authority under Section 25, subsection 1 of the Children Act, because the child has a history of running away and is likely to run away from any other type of accommodation. If it's important, this has to happen as well, that they were likely to suffer significant harm. So typically social workers will write statements in support of these applications explaining the history of the situation and the likelihood that they will suffer significant harm or injure themselves or other persons. And the statute is there. This is a case heard by the Family Proceedings Courts, so the Magistrates Court level, and they make decisions about whether or not the criteria under Section 25 have met, and whether then to detain the child in that situation. The Section 25 doesn't apply to a child who's detained under the Mental Health Act or being accommodated under Section 20, subsection 5 of the Children Act. It is a last resort in the same way the inherent jurisdiction application process is. And the courts have been quick to remind local authorities the fact it's an extremely serious step. It is locking up a child. It has an impact on the child, however, whatever the situation of that child and the young person's spirit, as the Mr. Justice Hayden then says. And so the courts will be slow to grant those orders, but they are made. That said, local authorities pay an awful lot of money to secure children's homes. For a year, it must be in the range of £300,000 for a room in a secure children's homes. And so local authorities are often loath to make that financial commitment with the financial strains that they are on. A child will have the right to legal representation. This is court proceedings. That legal representation can be funded through legal aid, as it still exists for those purposes. Important to note, and thanks Malcolm for making sure this bit was included, but the government is currently trying to amend Section 25 of the Children Act to permit other providers to provide accommodation akin to secure children's homes. And I know that private companies like Group 4 are very interested in this opportunity to provide secure accommodation within the meaning of Section 25 as it is being amended. But this is trying to deal with the problem that the courts, there was 2,500 applications to the High Court to exercise inherent jurisdiction. And the High Court judges are very annoyed by all of this time being taken up. And so the government is trying to create another way of providing relevant accommodation for purposes of securing children. And therefore, I have to say this is quite controversial. As I said, the local authority will apply to the court under Section 25 of the Children Act. And then obviously other providers will come forward to be able to essentially detain children. Periods of time set out in the regulations there. So initial application period is 72 hours. And then the court can actually then make an order, once satisfied it needs to make an order for a further hearing in 3 months' time. And those extensions can be made up to 6 months at any one time. And there's maximum periods all set out in the regulations there. There is a complaints procedure. Where a child is put in secure accommodation, there has to be at least 3. There's a panel, they call it a panel of 3 people, one of whom is not a member or an officer of the local authority, so they are independent. They will have secure accommodation reviews. The child's views and wishes should be made apparent in those wishes or views. Advocates can express those on behalf of the child. And then there's a complaints procedure for anything that goes awry in the children's home in the secure setting. With only 1 minute to go, I'm going to wind up there. Any questions? And thank you very much for your time and for being here today and for listening to myself and Malcolm, trying to set out as best as possible a very complex area of law.
Thank you very much indeed, Chris. Well, as I say, you will have slides. We do have some detailed notes as well. It is a vast area, but what we've tried to do is to give you some idea of how deprivation of liberty works, why it must be authorized in a different regime. So if you find yourself in a situation with a young person and you're not quite sure what to do, the first thing is to look at, well, what regime will apply here? That's the main thing. Obviously, we're going to open up for questions now, but obviously, any questions that you may have following on from this, I'm sure that Chris and I would both be happy to answer them as best we can. Anyway, so do we have any questions at all? Present, I can't see anything. I think that the weight of information we've given Chris has battered people into submission.
I can see that. I see that. Is it Shell? It just popped up. Was it Shell or Shelley who had a question? Apologies if I got your name wrong.
Oh right, I didn't see
it's
that.
Shell. Shell's raised a hand. Please speak if you can. You're on mute. Shell, are you able to? Aha.
Yes. Here we go.
A quick question. I'm acting for somebody at the moment who the local authority were going for a DoL application, However, they've now decided they're going for a Section 16 instead. Section 16 welfare. How does that work? Because that was a new one for me, and I'm a bit unsure about. It's a young person who is 3 to 1, not allowed out on their own.
Sorry, how old is the young person?
Currently 16, 17 at the beginning of January.
Okay, right. And it's a Section 16, you say?
Yeah.
Okay. And that's under the Mental Capacity Act, is it?
He lacks capacity. They have established that he lacks capacity, although it fluctuates. But
right. Okay. I have to say, I mean, I'd have to check the act. I think. I mean, Section 16. Sorry, what were they going to do beforehand? What do they have in mind? Is this an application to the Court of Protection?
yes, it was an application for deprivation of liberty because he is living in solo placement on his own. He's not allowed out on his own. He's 3 to 1 members of staff. Should probably be 4 to 1 members of staff.
So he's living in the community then. Yeah.
Yes.
Ah, right. Okay, so that's why they would make the application to the Court of Protection. So it's an application to the Court of Protection, and they say that they're using Section 16 of the Mental Capacity Act. I'm sorry, Shell, I'd have to look at the Act.
That's fine. It was just
to see how that would act. But I mean, I think if you go back to if you have a look at our notes, let's just have a quick look there and see what I've got.
I've done a quick look at the Act. So that would be an application to the Court of Protection to appoint a deputy. That would be to appoint someone else to then make decisions on behalf of the child in relation to their welfare or property and affairs. And there'd have to be, behind all of this would be an assessment about where the child lacks capacity. Is it in relation to their welfare? Is it in relation to their property and affairs? Or is it both? And the deputy is then, and then the deputy is appointed to be able to make those decisions in the best interests of the child themselves. What slightly, the thing that the way you described it was slightly caught my attention was saying it sounds like the child is already in a situation where there's quite a significant deprivation of their liberty.
And it's not gone to court. Yes, I know. I'm fully aware of that.
Yeah, that was. I'm thinking, hang on a minute, is this the cart before the horse? So that would potentially be. It might, there may be reasons to get legal advice about.
Yeah, that was the route I was heading down because.
Yeah, but also that there was an application to the court, then the local authorities we've seen has a duty to ensure that that they're legally represented. It's a requirement. They must ensure that the child is legally represented in those proceedings.
Yeah. Right. Thank you.
So, all right. Good luck with that.
Thank you.
Yes. Right. Anything else? Just looking at it, can't see anybody else who has any questions. Right. Okay. Well, I think what I'll do now is I'll close the seminar. As I say, if there are further questions, thank you again to Chris, who is much more experienced in this area than I am. But I'm most grateful to him for coming along. So that ends our seminar program for Lyme solicitors for this year. Next year, we will have a new program. I'm not quite sure what it's going to be, but it's going to be something that hopefully will be useful. So thank you again for attending. You should get your notes and slides very soon. and hopefully we'll see you all next year.
Thank you very much.